name is Dr. Mark Brannon, and I'm Vice President of the Board of the Princeton Adult School, and we all want to welcome you back to the second lecture in this series. I want to also, at the start, give thanks to the co-sponsors of this course and also co-sponsors of a number of our lecture series in the past, and that is the Princeton Adult School and especially the Community Auditing Program of Princeton University's Office of Community and Regional Affairs. And it's through the Princeton University's help that we are so able to meet here as we have for a number of years. So we really appreciate their participation. A couple of other pieces of a little bit of business before we get on to the actual lecture tonight. I want to once again make sure that everyone hears that we're not meeting next Tuesday on election night. We are going to skip next week, figuring that everybody had a lot of other things on their mind, so please do not come on the 4th of November, but come back 2 weeks from tonight, the 11th of November, when the Dean of the School of Management and Labor Relations at Rutgers, his name is Dean David Feingold, will speak to us on ethics and the biosciences revolution, the core issues for the 21st century. And this is another aspect, I believe, that is very important on bioethics, because it's the bioethics of industry, especially those that are in the life healthcare industry. I want to take a few seconds and say thank you especially to our speaker tonight on a personal level. Dr. Bob Pickens, who you will be hearing from tonight, I've known for over 30 years here in Princeton, and he has been the chair of the hospital's bioethics committee for many years. And when the members in the Princeton Adult School Board got together and we thought of having a lecture series devoted to bioethics, and this is some time ago now, maybe 2 years perhaps, my first thought was that we needed to go to Bob and to ask him for his help, and we have all benefited from his help and guidance in putting together the speakers and the topics for this whole series. So thank you, Bob, for that. I want to also say that we are lucky to have him here tonight because he and his wife Mary were last night present at the hospital where their son and his wife had their first child, but their 9th grandchild. So thank you for coming. I know you would have gotten around somehow or other, but we're glad that you're here and not worried about your daughter-in-law. And also on a personal level, my wife and I missed 2 weeks ago because we had a grandchild born, and then we had a second grandchild born from another son and his wife. So we're all very happy to be with you tonight to share this discussion. Thank you. Dr. Robert Pickens is our speaker tonight. Dr. Pickens is a graduate of Princeton University, class of 1961, and then he went to Yale Medical School, class of 1965. He completed his residency and urology fellowship training at Columbia Presbyterian Medical Center. Dr. Pickens is currently senior attending and chair of the Bioethics Committee of the University Medical Center at Princeton. As I mentioned, he is, I think you were the founding chair, but I know you have served as chair of this important hospital committee since 1985. Dr. Pickens has also served as the co-chairman of the Task Force on Institutional Ethics Committees of the New Jersey Bioethics Commission, and he has served as commissioner of the New Jersey Commission on Legal and Ethical Problems in the Delivery of Health Care. He's been a practicing urologist here in Princeton since 1973, and I bet many of you perhaps know Bob on a professional level. It is with great pleasure that I introduce Dr. Robert Pickens tonight, and his topic is A Tale of Three Women, the Legacy of Quinlan, Cruzan, and Schiavo. Please welcome Dr. Pickens.
Thank you all. Let me just make sure I have this turned on and you can all hear me. Can you hear me? Is this projecting? No. Higher on the lapel. Okay. tie. How's that? Better? Better, better, better? Better, better, better. Too high? Can you hear me now? Good? Raise your hand if you can't hear me. Thank you, Mark. It's really a privilege and an honor for me to have been asked to participate in this seminar. I mean, the topics and the speakers that you've chosen really are, outstanding. And these are leaders in their field, and I feel humbled and privileged to have been asked to be here. It's wonderful looking around and seeing the faces of old friends, old colleagues, current colleagues, and a number of patients. We won't breach any confidentiality, but it's nice to see some of my patients here as well, and my wife Mary, a new grandmother. A tale of three women: Karen Ann Quinlan, Nancy Beth Cruzan, Teresa Marie Tereshavo. Who would have thought that the tragic death of these three women in the prime of their lives, in their mid to late 20s, would have so completely revolutionized end-of-life medical decision-making at the end of the 20th century? Their legacy has firmly established our right as individuals and the rights of our families to speak for us in this modern medical world dominated by sophisticated medical technology. Now, to understand this transformation and the importance of their legacy, I will give you a little bit of an historical overview. It's important to know how we got from there to here. For centuries, it was the Hippocratic Oath, recited by generations of graduating medical students when it was written somewhere between 600 BC and 100 AD, that directed the course of medical treatment for the sick and defined a patient's professional behavior with regard to his patients. In the modern era, Thomas Percival's treatise entitled Medical Ethics further guided the conduct of medical professionals when it appeared in 1803. Central to Percival's treatise on ethics was the role of the virtuous character of the physician. And it was this virtuous character that was meant to guarantee your well-being and the good of his patients. This obligation of the physician to the patient has remained to this day, but it has become complicated by dramatic changes in medical technology, which have demanded a new thinking and a new vocabulary. The very nature of the physician-patient relationship has changed. Medicine has been subjected to the rules of the marketplace. We talk about consumer and provider and think of medical transactions as if they were contracts or commodities. And yet the delicacy and sensitivity of medical decision-making remains as acute today as ever before. Why is this? I mean, illness is a universal, perennial human experience. There's a distinct gap in knowledge and power between the patient and physician at the time of decision-making. The health professional brings his understanding and expertise about sickness and death to patients who are extremely vulnerable because of injury, because of disease, because of the approach of death. This vulnerability may compromise bodily integrity and render the individual unable to make decisions with full competence. When we talk about the patient-physician relationship, we're talking about the application of ethical principles that are firmly established in the history of medicine and public health. These principles serve as action guides for the very delicate and special relationship that exists between the physician and the patient. We, as a civilized society, believe that it is a violation of our social and professional duties to fail to benefit others when we can do so, and also to refrain from harming individuals when we can refrain from doing so. For centuries then, the ethics was a simple matter. The patient relied on my moral goodness, my virtuous character, to do the right thing. It was the virtue of the doctor, inspired by the Hippocratic Oath, that was the focus of attention. Our attention was not on the acts, on the things that the physician was doing, because there were not very many things that physicians can do, if you think about it. We could hold a hand, we could comfort the sick and dying, but we did not have a whole armamentarium of highly sophisticated technological procedures at our disposal. So, if you look at a typical healthcare scene mid-century, in the 50s of the last century, the majority of physician and patient contacts were in the home. You remember house calls? The physician was often a neighbor, often of the same religion as the patient, who could be counted upon to approach the patient's medical problems and values that were similar to his. If a patient needed to be hospitalized, it was most often in a local community hospital or a religious hospital where there was indeed an intimacy of shared values. If a physician recommended medication or surgery, there was a polite thank you, and the patient followed the physician's recommendations without any further questions. We use the term paternalism to describe this relationship. It was very one-sided. The physician recommended, the patient followed. Now, if you were to read the American Medical Association Principles of Medical Ethics, published in 1957, about mid-century, which has a preamble and 10 sections, you would note that the focus of the principles is totally on the physician in dealing with patients, colleagues, and the public. Very little is said about the patient. Contrast this with a scene today. The patient's medical contacts are more likely to be in the physician's office or the hospital emergency room. The patient's physician is not a neighbor, but a specialist, perhaps part of a multi-specialty group who was trained at a major medical center in Boston or New York or Philadelphia. He is probably of a different religion and cannot be counted upon to have the same values as the patient. When a physician suggests medication or surgery, a patient is more likely to ask questions about risks and benefits. The patient often seeks a second opinion or asks about alternatives. What has happened to bring about this change? 3 factors have been predominant in spurring this change. The first one has been the absolute explosion of medical technology. Death is no longer a quiet event at home. As David Thompson, former head of New York Hospital, was quoted in the New York Times in the mid-'80s, "When I was an intern, you held the hand of a dying patient. Now, bulbs go off, people rush in, so if a patient dies, something must have gone wrong." We have heart and lung machines that keep patients alive artificially, indefinitely. We place artificial feeding tubes to sustain nutrition and hydration. We do heart and kidney transplants. We have prostheses to replace old joints and sustain sexual function. Extremely low birth weight infants who might previously have died are kept alive and flourish. We do in vitro fertilization, explore genetic engineering, gene mapping. It's obvious that the burden of all this modern technology has made medical decision-making for the individual patient and his or her family a very complex affair. Modern technology, first driving force. A second major force for change was the emergence in the 1960s of a new individualism with emphasis on individual rights. This was manifested by many social movements, the women's movement, the ecology movement, the civil rights movement, the peace movement, the anti-poverty movement. Ethics in medicine now took on a new dimension that was much more patient-oriented. The ethic looked more at the act that was being performed, the respirator, the feeding tube, rather than at the actor, the physician who was performing the act. It became the ethics of treatment decision-making. It looked at the appropriate use of heart and kidney transplants and the appropriate application of artificial respirators and feeding tubes. These acts now became the focus of attention. The emphasis here was on the principle of patient autonomy, with the need for the physician to disclose all information to a patient that would allow him or her to make an informed choice about healthcare treatments. It was during these times that new codes of medical ethics were written. You remember I briefly mentioned the AMA principles in 1957, which were quite physician-oriented. These were joined by more patient-oriented codes, specifically the American Hospital Association's Patient Bill of Rights, written in 1973. Among those items emphasized in this Bill of Rights were the patient's right to obtain complete current information about diagnosis, prognosis, treatment, and the right to every consideration of the patient's privacy, and the right to refuse treatment to the extent permitted by law. It was at this time, in 1973, that the landmark Roe versus Wade decision by the United States Supreme Court, protecting an individual's right to privacy and thereby legalizing abortion, was forged. In 1976, just 3 years after that, the New Jersey State Supreme Court ruled in the case of Karen Ann Quinlan and protected her privacy in the determination of her health care. In just a couple of minutes, we'll talk a little bit more about Karen Ann Quinlan. Two factors: modern technology, a new individualism, and the third factor that has collaborated to make healthcare choices more complex today is a raised consciousness of the role of values in medical decision-making. The physician's values are no longer the ones that determine the patient's decision-making. As professor of ethics at Georgetown University's Kennedy Institute, Dr. Robert Veitch has pointed out, values penetrate every decision, every medical decision that is made. This covers the entire spectrum, from deciding which blood test to order to determining whether a patient is dead. There is no reason to presume that the patient would have the values held by the professional to be the ones that determine the choices that must be made. All three of these factors then, modern technology, emphasis on individualism, the role of values, have come together to create a new ethical model of shared decision-making as the norm for healthcare choices. Physicians have come to understand that shared decision-making promotes trust within the patient-physician-family relationship. It recognizes that within this triad, each member brings to the relationship special knowledge that the other lacks. The physician brings his medical knowledge and skills as well as a set of professional values and goals. The patient and family bring their personal values and goals, which are necessary to the weighing of risks and benefits of treatment. Shared decision-making has placed a new burden on the physician. His schooling, his residency, professional oath emphasize positive actions to sustain and prolong life. Physicians do not easily accept the concept that it may be best to do less rather than more. The decision to pull back is much more difficult than the decision to push ahead with aggressive therapy. And today's sophisticated medical technology invites physicians to make use of all means at their disposal. There is, in addition, the uncertainty of diagnosis and prognosis, often making it difficult to predict the length and quality of a patient's life with or without treatment. And of course, the fear of liability often interferes with the physician's ability to make the best choices. The landmark case in the transformation of end-of-life medical decision-making shocked our consciousness in the 1970s. This was the case of Karen Ann Quinlan. It was a pivotal event in the context of the entire concept of the so-called right to die. Prior to the Quinlan case, there had been great reluctance to permit patients to refuse treatment when that treatment refusal would lead to death. The Quinlan case made it clear to the courts what healthcare professionals were beginning to experience, and that is that there was an increasing range of situations in which treatment would keep patients alive, perhaps in a vegetative state, but would not restore them to health. Many of you remember Karen Ann Quinlan in the 70s. Karen was a 21-year-old young woman who became unconscious after coming home from a party and stopped breathing for 2 15-minute periods. Resuscitation was attempted. However, in the emergency room, her pupils did not react to light, and she did not respond to painful stimulation. She was placed on a respirator, and 3 days later, she was dependent on it. Karen had been born on March 29th, 1954, to a young, unmarried mother of Irish-American ancestry. A few weeks later, she was adopted by Joseph and Julia Quinlan, devout Roman Catholics who lived in Landing, New Jersey. Shortly after Karen turned 21, she moved out of her parents' home, moved in with some roommates. About the same time, she went on a radical diet, reportedly to fit into a tight dress. A few days after moving out, she attended a friend's party. It was reported she had not eaten anything in a couple of days. At the party, she apparently had a few drinks, took a tranquilizer, and felt faint. She was taken home and put to bed. When friends checked on her about 15 minutes later, they found she was not breathing. Karen was taken to Newton Memorial Hospital in New Jersey in a coma. She remained there for 9 days in an unresponsive condition before being transferred to St. Clair's Hospital. Karen had suffered irreversible brain damage after experiencing an extended period of respiratory failure. She was finally diagnosed as being in a very deep coma, very deep form of unconsciousness, which was characterized as a persistent vegetative state. After seeing Karen like this for several months, her family came to the conclusion that she was beyond hope and decided to remove her from the ventilator. Karen's father discussed the matter with his priest and then requested that the respirator be discontinued. The hospital and attending physician refused, regarding this as a violation of medical ethics. The local prosecutor and state attorney general all threatened criminal proceedings. The Quinlan family persevered and in 1976 took their case to the New Jersey State Supreme Court. In its landmark decision, the New Jersey Supreme Court recognized Karen's right to refuse medical care. The justices further decided that her individual constitutional rights to privacy and her right to refuse medical care did not terminate because she was in a coma and incapable of medical decision-making. The court recognized the ability of her father to act in a role as a surrogate for this decision-making. Following the New Jersey Supreme Court, many other states have found legal sanctions for this right from both the constitutional right of privacy and from the common law principle that an adult has the right to determine what should or should not be done with his or her body. It is now legally recognized that a competent patient may refuse treatment of any kind, including the artificial administration of nutrition and hydration, even if the outcome should be death. This right remains intact for a patient who is now incompetent, but who was previously competent and left either written or verbal instructions about his or her health care. This concept gave birth to the living will concept or the advanced directive concept, with multiple states enacting legislation to legalize the writing of a living will. New Jersey's Living Will Statute, or Advanced Directive for Health Care Act, was enacted in 1991, and you'll be pleased to know that it is perhaps the most comprehensive living will statute in the country. The right to refuse medical care has also been upheld for any incompetent patient who was previously competent but has left no specific instructions, but whose family has the right to act as a surrogate for this decision-making. Who else should know or would know best the wishes of a loved one? Certainly not a stranger, certainly not a judge, certainly not a court. The family has time and again been upheld as the appropriate jurisdiction for decision-making when a loved one cannot speak for themselves. It should be noted, by the way, that once Karen's ventilator was removed, she lived another 9 years and died in 1985. Just 2 years before her death in 1985, another young, vital 25-year-old was propelled into the national spotlight. On the night of January 11th, 1983, Nancy Beth Cruzan lost control of her car as she traveled down Elm Road in Jasper County, Missouri. She was not wearing seat belts. The vehicle overturned and she was thrown from it and landed face down in a water-filled ditch. She was discovered without detectable respiratory or cardiac function. Paramedics were able to restore her breathing and heartbeat at the accident site. and she was transported to a hospital in an unconscious state. An attending neurosurgeon diagnosed her as having sustained cerebral contusions compounded by a significant lack of oxygen. She remained in a coma for approximately 3 weeks and then progressed to an unconscious state in which she was unable to orally ingest food and water. In order to ease feeding and further the recovery process, surgeons implanted an artificial feeding tube into her stomach with the consent of her husband. Subsequent rehabilitative efforts were unsuccessful. She was ultimately diagnosed, as Karen Ann Quinlan had been diagnosed, as being in a persistent vegetative state. Her husband and parents waited for more substantial recovery, however, after 4 years, accepted that there was no hope. Persistent vegetative state, by the way, needs a little clarification. It's not, persistent vegetative state is not brain dead. Brain dead is total loss of all functions of the brain. Somebody who is brain dead is dead, can be pronounced dead, and can be buried. Persistent vegetative state is the loss of essentially cerebral function. The medulla, cardiac, and respiratory portions of the brain may still be working, but everything in the cortex is gone. There is no meaningful interaction. Many people confuse persistent vegetative state, brain death, unconsciousness, but there are very important distinctions about the differences. After it became apparent that Nancy Cruzan had virtually no chance of regaining her mental facilities, her parents asked hospital employees to terminate the artificial administration of nutrition and hydration through the artificial feeding tube. All agreed that such removal would allow her to die. The employees of the hospital refused to honor that request without court approval, and the Cruzans took the case to a local court. And the local court indeed found that a person in Nancy's condition had a fundamental right under both the state and federal constitutions to refuse or direct withdrawal of death-prolonging procedures. The court also found that Nancy had expressed thoughts at age 25 in a conversation with a roommate that if she were sick or injured and had to be sustained with a feeding tube because she could not eat, she would not want to live that way. The court ruled in their favor. However, the prosecutor took the court further to the Missouri State Supreme Court, which reversed the decision. The court recognized her right to refuse treatment, but expressed skepticism about her statements to her roommate regarding her desire to live or die under certain conditions, and felt that the statements were unreliable and that there was no clear and convincing evidence that this is what Nancy would want. The Cruzans persevered. The case subsequently proceeded to the highest court of the land, the United States Supreme Court. The issue that was brought to the United States Supreme Court was whether the state of Missouri had the right to require the clear and convincing evidence standard in judging whether she could have her feeding tube removed. In a 5-4 decision, the United States Supreme Court actually found in favor of the Missouri Department of Health, meaning that it was their judgment that the Constitution permitted the state to have those specific criteria of demanding clear and convincing evidence. However, the court did uphold the legal standard that competent persons are able to exercise the right to refuse medical treatment under the Due Process Clause of the 14th Amendment. So this right is indeed protected by the 14th Amendment. Because there was no clear and convincing evidence of what Nancy wanted, the court did uphold the state's right to demand that. However, 2 other very important issues came out of this ruling, one from Justice O'Connor and one from Justice Scalia. Both of them concurred in the 5-4 decision permitting the state of Missouri to demand clear and convincing evidence. But both O'Connor and Scalia felt as the majority had, that there is indeed a protected interest in refusing unwanted medical care And Connors went on to say that the refusal of artificial administration of food and water falls within that ability to refuse. So she made no distinction between the artificial administration of food and hydration and the artificial administration of ventilation or cardiac function. Justice Scalia went on to support the ruling. However, he made it clear that he would have preferred that the court announce clearly and promptly that the federal courts have no business in this field, and that the point at which life becomes worthless and the point at which the means necessary to preserve it become extraordinary or inappropriate are neither set forth in the Constitution or known to the 9 justices on the Supreme Court. And it was his ruling that it was up to the citizens of Missouri to decide through their elected representatives whether the wish to refuse treatment will be honored. After the case was decided, the family apparently went back to Missouri, were able to find more clear and convincing evidence that this is what Nancy Beth Cruzan would want, and the court ordered the hospital to remove her life support. Nancy Beth Cruzan died on December 26, 1990. Her grave marker is inscribed as follows: Nancy Beth Cruzan, born July 20th, 1957, departed January 11th, 1983, at peace December 26th, 1990. The ruling from the Supreme Court of the United States was dated June 25th, 1990. Earlier in that same year, February 25th, 1990, Teresa Marie Terry Schiavo collapsed in her home. She experienced respiratory and cardiac arrest, resulting in extensive brain damage, and ultimately a diagnosis, along with her 2 predecessors, of being in a persistent vegetative state. Terry was born on December 3rd, 1963. At the time of her collapse, she was 27 years of age. Terry grew up in a suburb of Pennsylvania. While a senior in high school, she was 5'3" tall and weighed 200 pounds. Terry met Michael Schiavo in 1982, and they were married in 1984, and at the time of their marriage, she weighed 142 pounds. On the morning of February 25th, 1990, Terry Schiavo collapsed in the hallway of her apartment. She was not breathing, had no pulse. Paramedics arrived, attempted to resuscitate her. The cause of her cardiac arrest had never been determined, but it was thought most likely to be because of lack of nourishment. Her medical chart noted that she had apparently been trying to keep her weight down with dieting and had been drinking about 10 to 15 glasses of iced tea a day. Michael Schiavo filed a malpractice suit against Terry's obstetrician, claiming that he failed to recognize and diagnose bulimia in her. The jury awarded him $1 million in 1992. Terry Schiavo remained comatose for 2.5 months. She finally had a percutaneous feeding tube surgically inserted into her stomach, and she was diagnosed as being in a persistent vegetative state within 1 year after her cardiac arrest. In 1988, 8 years after her collapse, her husband, Michael Schiavo, who was her guardian, petitioned the Pinellas County Surrogate Court to remove her feeding tube. Robert and Mary Schindler, Terry's parents, opposed. Legal battles ensued. At this point, however, the legal struggle received no notable public attention. This phase ended with her husband's initial petition to have her feeding tube removed and involved 4 legal decisions. Michael did not directly make the decision about whether Terry should live or die. He petitioned the court asking it to act as Terry's surrogate and determine what she would decide if she were able. And here's where the nightmare began. This controversy lasted 7 years, included involvement by politicians and advocacy groups, the governments of Florida and the United States, both of which passed legislation that sought unsuccessfully to prevent removal of Terry's feeding tube. These events now resulted in extensive national and international media coverage. You won't believe this, but her tube was removed in 2001 in April. The tube was put back in April of 2001. The tube was removed in October 2003. The tube was put back in October of 2003. By 2005, a legal history surrounding the Schiavo case included 14 appeals, numerous motions, petitions, and hearings in the Florida courts, 5 suits in federal district courts, Florida legislation struck down by the Supreme Court of Florida, a subpoena by a congressional subcommittee, federal legislation, and finally 4 denials for review from the Supreme Court of the United States. Terry's feeding tube was finally removed, and she died at Pinellas Park Hospice on March 31st, 2005, at the age of 41. What then is the legacy of these 3 women and their brave families? The Quinlan case recognized from both the constitutional right of privacy and from the common law principle that an adult has the right to determine what should or should not be done with his or her own body. It is now legally recognized that a competent patient may refuse medical treatment of any kind, including the artificial administration of nutrition and hydration, even if the outcome should be death. This right remains intact for a patient who is competent or a patient who is now incompetent and is left written or verbal instructions about his or her health care. In the Quinlan case, the court further recognized the ability of Karen's father to act as a surrogate for this decision-making. The Cruzan case, 14 years later, took the issue all the way to the United States Supreme Court, which once again affirmed on the basis of the Due Process Clause of the 14th Amendment that there is a right to refuse unwanted medical treatment. In this ruling, as I mentioned earlier, the court also strongly reaffirmed the state's right to require clear and convincing evidence, and it also clearly stated that this should not be an issue for the courts to decide, that they are no better equipped to determine at what point life is no longer worth living and at what point means to preserve it become inappropriate. The Cruzan case also firmly reiterated previous rulings that the artificial administration of nutrition and hydration can be refused just like any other artificial treatment, whether it be an artificial respirator or kidney dialysis. Because of this acknowledgement that states had the right to demand clear and convincing evidence, the whole issue of living wills and advance directives was once again propelled back into the mainstream, and the writing and execution of living wills after the Cruzan case accelerated. Finally, the legacy of Terry Schiavo, first of all, supported the legal role of Michael as the appropriate surrogate for his wife, even though Terry's parents had a conflict. The court also supported Terry's right to refuse unwanted medical treatment expressed through a surrogate, though she was no longer able to speak for herself. The Schiavo case confirmed once again, despite many cries against it, that the artificial administration of nutrition and hydration qualifies, along with other artificial medical treatments, to be discontinued if the patient so desires. The most poignant aspect of the Schiavo case was the unfortunate tragedy of the public spectacle that followed the case through the media. Terry's dying should have been a personal, private affair confined to the family. Statements and opinions from presidents and governors and legislators and right to life advocates and the Pope should play no role in the very personal and private decision-making process. What are the lessons we have learned from these women? Number one, that dying should be a private affair, an affair confined to the patient and the family and the physician. Number two, we've learned that our Constitution and the common law protects this right, protects our right to make healthcare decisions for ourselves, unencumbered by the courts who have no greater insight, by advocates who have no greater insight. And finally, the lessons are we better make our wishes well known. Make our wishes well known by the writing of living wills and advance directives, and the appropriate appointing of surrogate decision makers who know how we feel, who can speak for us, who can stand in our shoes when we can no longer speak for ourselves, so they can communicate with physicians about the wishes that we would want fulfilled. The tale of three women, Karen Quinlan, Nancy Cruzan, Terry Schiavo. Their legacies have forever transformed medical decision-making for us in the 21st century and has supported our rights of privacy and the rights and privacy of our family in making painful, personal, intimate, end-of-life medical decisions in conjunction with our own personal physicians. Thank you. I'd love to... This is the time I look for. This is the fun now. I'd love to entertain questions. Mark, we have time? Yeah. Okay, here's a gentleman who raised his hand quite quickly.
The right to deny supportive care and thereby die at peace is one aspect. The removal of supportive care is a slightly different aspect, both protected by the Constitution. How do these affect someone who wishes to, who's still alive and compos mentis, who wishes to have an assisted suicide? Does it have, in other words, to die in peace, who has a terminal illness? That's a third factor.
Yeah, I knew you'd ask. The easy question first. Well, first of all, let me start off by saying, don't let me forget the second part. There is no moral distinction between the withholding or withdrawing. Morally, they are the same. It may be much harder to stop treatment once you've started it, but there is no moral distinction between not doing something or doing something and realizing it's inappropriate or harmful or not helpful and removing it. So there should be no moral distinction, but it's much harder to withdraw than to not start in the first place. You know, the whole issue of assisted suicide, I'm sorry, I have strong feelings against it. It's an issue for a whole other seminar series, whether there is a role for assisted suicide, whether physicians should be the ones to participate in that role. It has been thought to be a violation of all ethical principles in medicine to have physicians intentionally kill a patient, to participate in the intentional killing of a patient, which is not the same as withdrawing treatment and allowing a natural process to take place. There are some people who nitpick and say, withdrawing is assisted suicide. You're withdrawing something and the patient therefore is dying. But it is the intent. If the intent is to actively kill somebody by doing something, that is different than removing treatment and allowing a natural process. We've created this conundrum by creating this medical technology. Let me die in peace. So when you take something away, you're allowing a natural process to take place. That's one way of looking at it. That's not everybody's way of looking at it. But it really has to do with the intent of treatment. If the intent of treatment is to give high doses of morphine to alleviate pain, and the patient subsequently dies because of that, that is not active euthanasia from my perspective. That is treating the pain. That is making the patient comfortable, and the secondary effect is perhaps death. But that is not active euthanasia.
Specifically with this Chavo case that had the issue of the husband's rights versus the parents' rights, has anything been determined about how to assign a chain of command of responsibility among family members as to who gets to make the decisions, who is more important?
Well, yeah, excellent point. Excellent point. Michael legally When somebody marries, the husband is the guardian, at least in the state of Florida, and the parents are no longer guardians, which, can often be sad. I mean, if the husband's a nasty guy, he still legally is the guardian. In terms of assigning a pecking order of who should be your surrogate decision maker, that's what you have to do in your advance directive. You have to appoint a surrogate and appoint alternate surrogates in the order that you would like them to participate in your healthcare. Why would you choose alternate surrogates? Well, you become incompetent and you've appointed a surrogate and they're not available, they're in California, they are mentally distraught, they can't act for you, then you go down to the next surrogate. You don't want decision-making by committee. The worst thing is to have a dysfunctional family who are pulling this way, pulling that way. What you need to do in your advance directive, and this is one of the most important things to come out of this, these three cases, make your wishes known in an advance directive, but appoint a surrogate who has the legal right to speak for you, and don't be concerned about hurting people's feelings. You want to appoint your eldest son because he's going to have hurt feelings. Appoint the person whom you believe can step into your shoes and speak for you and represent you, not represent themselves, but represent you.
But in the case where you don't have advance directive and the courts have to decide,
there is a pecking order, and the husband becomes the first in line, and then parents, children next. Parents are unfortunately parents of married children get to the bottom.
Is that recognized in every state?
Every state has its own, unfortunately, has its own. In fact, most states don't have laws. There's no such consent law within the state of New Jersey. There's no pecking order that is codified in law. These are the medical principles that we use in dealing with patients that are respected. Much of what we do in medicine is not in the law books. More of it is coming into the law books. But traditionally, for years, physicians practiced medicine on the basis of sound ethical medical principles. There were no laws. We didn't have to go to the law book to find out what to do. I mean, if you think about it, this whole right of privacy issue, is something of a fabrication to present a legal basis for it. Most states do not have specific legislation that outlines the pecking order, and it is a tradition within the health profession within that state as to what the pecking order should be. Let's go up top. Yes. Yes, blue top.
About 30, 31 years ago, a woman gave birth to a child who had severe medical problems. They were told that the child would die unless there was an operation performed. But if the operation was performed, that child had at most 6 years to live in severe pain with little quality of life. They elected a 3-month-old to bring about. Parents decided not to have the operation done, and the state stepped in. The government, whatever agency it was located, said the operation is mandated.
Yeah.
That situation happened today. What's changed in dealing with children, parents' rights, that kind of thing?
Mike, you're smiling.
Not an uncommon problem.
Yeah. The state, the state maintains certain rights. That's to, protect the vulnerable, and certainly children are vulnerable. Although throughout history, we respect the role of parents as the appropriate decision maker and surrogates for their children. They're the ones that have to live with the decisions and live with the children. So there were the baby Doe case, Mike, in the 80s, where the government stepped in, and this was a Down syndrome child, and trying to legislate, treatment for this circumstance because it was really a quality of life issue. It's one thing. There's a classic story about an anencephalic child, a child that literally was born without a brain. And that was a child who was going to die. In fact, these children usually die within a couple of days or weeks after birth. This child happened to have lived for about 18 months and no brain. There was no hope for this child, and that the mother kept coming back to the emergency room and asking that the child be resuscitated every time the child had an arrest, because what she said was, I take this child home and he's a warm beating heart, and I'm able to coddle him and hold him. And the emergency room was required each time to fulfill that obligation, and he died within 18 months. No hope for to live whatsoever. When you get into disabilities like Down syndrome, then it becomes a quality of life issue, and I think the state often will step in and mandate that child be protected. I don't know whether this was a Down syndrome child that you were talking about, but yeah. 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 Well, I would say today we respect the rights of parents as the appropriate surrogate for children. They have to assume the responsibility, for making the decision and living with the decision, and that you'd be hard-pressed to have the state intervene and say you must do. Way up on top.
Quality of life becomes a bigger issue with aging individuals, not always mentally competent. And the question is, where is the medical profession going in attempting to help make those decisions?
I'm not sure. I'm not sure the point of the question. I think in terms of helping the aging make those decisions is trying to get them earlier in life to make those decisions. In other words, to execute a living will, for example, an advance directive earlier, before you reach that point where you have become incompetent. So earlier in life, executing an advance directive, talking to a loved one who will act as a surrogate for you, and updating that on a periodic basis depending on your health. We want nothing more, physicians want nothing more than clear and convincing evidence of what you would want. So as best you can do to make it clear what you would want, we will honor.
But aren't physicians being called upon more and more to discuss and look at the alternatives that are available, quality of life versus sustenance of life?
Absolutely, and I think the point I tried to make was that one of the predominant factors in decision making is the value system, and we have come to realize that it's not my value. I might not want to do that, but it's not my value system that should determine the decisions that have to be made. It's your value system. So if we can understand your value system, we may not agree, and I may say, hey, I am not going to support you in that. If that's the case, it's my obligation, my professional obligation, to find somebody who will, short of something being crazy, somebody who, doesn't have appendicitis and wants me to remove their appendix just because, a dream told them to do so. But, it's not my value system that determines the decision making. It's your value system. If we have a conflict of value systems, then I need to step aside. And we have that. The classic examples are in many religious-based hospitals. Questions about abortion, for example. Don't come to my Catholic hospital asking for an abortion. I will not do that. If your value system supports that, then you need to go to a place that will support your value system.
You talked about three factors of painful landscape of decision making. I'm wondering about a fourth one.
Good, thank you.
Which is the
variety of sources of who's going to pay for this kind of care. You know, it can be the federal government, it can be the state government, it can be insurance, it can be private pay, it can be hospital charity care. And to what extent does that enter into the decision-making process? I vaguely remember while the Shiloh thing was going on, there was a baby in Texas that where the mother wanted the baby kept alive, and the hospital decided to withdraw care. And that may be the wrong memory, but but the question is, how do we factor in that?
No.
Who pays and the extent of
No.
the cost?
Well, I mean, cost is the 800-pound gorilla in the room. I mean, there's no question about it. We haven't gotten to that point where we are willing to say our resources are limited. Maybe we have reached that point, yesterday. Our resources are limited, and therefore money will be a factor. We're not going to, open heart surgery has been done on 100-year-olds. We're not going to do open heart surgery on a 100-year-old because we're going to take that money and vaccinate, 1,000 kids in the inner city. We haven't come to that point yet.
Yeah, but we're not vaccinating 1,000. We're not making the decision that way, the way you just described, where we're taking this and that. But there's all kinds of care we don't deliver because somebody decided we don't have the money to do it. So it's just the decisions aren't being made as quite as directly.
Yeah, and we still worship the individual in our society. We don't worship the community. We don't worship community values, meaning, we're looking at a healthy community and how do we pay for having a healthy community? We still pay for, having your heart transplant or your, we've always been criticized. The rest of the world criticizes us for being so individual oriented, and it's what has made us great, and it's wonderful, but it also can be a negative. We really haven't addressed those issues in our society.
Are the ethical standards in our country very different from those in, for example, France or England or European countries, as far as the decisions in the cases that you mentioned?
Yeah, there are differences, yes. I mean, the Netherlands has a euthanasia culture, which makes decision making much different there. And the point I just made, there are many European countries who respect community values and the just distribution. When there are nationalized health systems, they're more into, for better or for worse, they're into the just distribution of benefits over a larger spectrum. In my specialty, prostate cancer, you get very little treatment for prostate cancer in many of the European countries. And that has to do with the distribution of resources and the use of money. And yeah, there are differences. We still stand behind the individual and individual autonomy and what's best for the individual, not necessarily what's best for society.
If an ambulance crew is called to pick up an elderly person, say, is the paramedic required to treat the person regardless of a living will?
Great question. The paramedic, unfortunately, is there urgently. Paramedic is not there to read the living will and figure out what you would or would not want. Now, there is an option. There's something slightly different concept. DNR order. Do you know about do not resuscitate order? That's an order. You go into the hospital, and if you don't request a do not resuscitate order, every person who's in the hospital will be resuscitated if they do not have a DNR order written on their chart. If you haven't told your physician, I have terminal cancer, if I go into the hospital and have a cardiac arrest, don't resuscitate me. If you don't tell your physician that, every hospital in this country will resuscitate you. So you really need to make an affirmative commitment, affirmative statement to your healthcare provider. I don't want to be resuscitated. And most often it'll be respected. Now, if you go in and you're having a lousy day and you tell the doctor, I don't want to be resuscitated, that's not going to. Now, the reason I elaborate a little on the DNR, there is an out-of-hospital DNR option. One can have a DNR order that would apply to the rescue squad, signed by your physician. You wear a bracelet that alerts them that you are a DNR. You put a sticker on your refrigerator that alerts them. So there is that option. And what is that? That's usually for an elderly, debilitated patient who's going home to die. And if you have that designation, the rescue squad will honor that. But you see, you say if somebody has a living will, what do they do? Remember, a living will is not a right to die document. It's a communication tool. He may open that living will and it says, under certain circumstances, I want you to do everything possible that you have, to treat me. The living will isn't just a I don't want document. It's an I want document as well. So some living wills say, if I want you to resuscitate me, I want you to go to the wall to keep me alive under any circumstances. And you have the right to do that in your living will. So a living will isn't just I don't want. It's a right to choose document. It's not a right to die document.
So different states have different laws in the sense that I'm thinking of a friend of mine whose 20-odd-year-old son had an advanced directive. He had many illnesses, did not want to be on a resuscitator, did not want anything extraordinary to happen. He ended up on a resuscitator. And in the state of Florida, at that time, 2 doctors had to agree that he would die imminently in order to take him off the respirator. And there was a discussion in the hospital, but the doctors didn't agree.
Yeah. Okay. Well, the fact is, every state has their own advanced directive statute. And something I mentioned to you, you can be proud that the state of New Jersey has the most comprehensive advanced directive statute in the country and the world. I mean, it has the greatest clarity and the greatest options. Some states say, you can only have a terminal illness to be removed from unwanted treatment. The state of New Jersey outlines many other. I mean, there are more things than terminal illness. Permanently unconscious. You can be unconscious. Karen was in a vegetative state for 9 years. Karen would have qualified in this state to have care terminated. The point is that, yes, it's different in different states. Each has their own law. The reality is that, most states have pretty much come around to respecting living wills and helping you to fulfill them. Missouri became, was a little bit maligned as, I guess Missouri is the show me state, isn't that right? Yeah, Missouri, the show me state. Show me the clear and convincing evidence. But the United States Supreme Court supported them in saying, you have a right to set up that criteria, those criteria, before we will remove life support.
Was having the most comprehensive medical directive statute mean that one needs a particularly detailed living will in New Jersey?
No, good question. No, I mean, there's no one form that is required. When I say comprehensive, what I meant was the range of circumstances under which the law will protect you to have life support removed is really more comprehensive and larger than any other state. It's not just terminal illness. There's no specific one form that you need. The most important thing for me, and having been in the debate as to, okay, here's an advanced directive. So what does this really mean? What did the patient mean? appoint a surrogate, with whom you've discussed what this means. So when I can't talk to you, I can talk to your loved one, and they can say, we had a conversation. This is what she meant. That's the most important part of the living will statute, I believe, is the appointment of a surrogate, discussing with the surrogate. We don't like to discuss death and dying. I mean, that's part of the problem, why these documents are, often useless, because we never discussed them. We've signed our name, we've put it in the safe deposit box, nobody has discussed it. And that's part of the issue. Discuss it. Even if you haven't appointed somebody in your family as the surrogate, tell them that they're not the surrogate. So when the time comes, they don't say, how did this happen? And update it. Carry them around with you. If you have executed a living will and it's in your safe deposit box at the house and you end up at the hospital, the living will doesn't exist. I mean, you can't say to somebody as you're entering the emergency room, I have a living will, well, what does it say? I mean, are we supposed to wait for somebody to go to the house? So make sure your doctor has it, make sure the hospital where you're likely to be hospitalized has it, make sure your children have it, or at least understand where to find it. If it's not in the hands of a healthcare provider, it doesn't exist. Somebody who is not,
Bob, in spite of 30 years worth of the awareness by the public of the need for living wills and the right to privacy, we in the healthcare business know that most people don't actually execute a living will. And if one were to take a show of hands here tonight, I bet there will be some people who haven't written their own living will. And I would like you to speak to the issue of I think it's the federal rule now. So every state, whenever a person enters the hospital, that question is asked of them, if I'm correct.
Yes.
Is that right?
Yes.
So once you get sick enough to go to a hospital, at least somebody will ask you if you've written one.
The federal law, the Patient Self-Determination Act, which is enacted about the same time as New Jersey's Advanced Directive for Healthcare Act, requires hospitals at the time of your admission to ask if you have a living will. Admission to the hospital is not predicated on you having one, but they are required to ask. If you say yes, then they will ask you, may we have a copy, and we'll put it on file. If you say no, they will ask you, would you like information about it? We can get somebody to help you execute one. And if you say no, thank you, then you move through the system the same way that somebody who is not executed a living will. But that was a catalyst to the writing of living wills, and it's an obligation of hospitals who receive funding from Medicare and Medicaid to ask you at the time of admission, and have set up a system to provide you with help in executing it if you don't have one.
Couldn't that be put into online database of the hospital? Every time you go in there to have a test,
Yeah.
you give them all this information, for any records, because why can't it be asked then, and you can say, yes,
Yeah.
I have it, you can have it.
Yeah. We're trying. We're trying. It's not that easy, but yes, that everything is going into a database now. But once again, you've got to be careful. You can't just enter it and store it and assume that it's valid, for eternity. I mean, one of the important factors about a living will, it needs to be a fresh, living, updated document. So, what would happen is it would click out after a year or 2 years, and somehow we'd have to get back to you and say, your living will is now becoming obsolete. Do you want to do it again? I mean, there are aspects like that that make it slightly more complicated.
I have a really specific but technical question.
Yes.
What rules the state of residency or the location where somebody might enter the hospital or become incapacitated? So if my elderly mother is visiting me, but her residence is somewhere else and she becomes incapacitated, which state rules?
It's a good question. I can tell you in the state of New Jersey, from personal experience, again, because of the breadth of the New Jersey statute, New Jersey will honor anybody's advance directive. But this is a state-by-state prerogative. Not every other state will honor New Jersey's advance directive statute. Because it is wider and broader. And if it's a state that says, we're only going to honor it in a terminal illness, and your mother doesn't have a terminal illness and she's in state X, Y, or Z, they legally. Now, you got to remember, advance, what we might want more than anything is information about what you'd want. And even before living will statutes, even before it was codified in law, if somebody wrote their wishes down on a piece of paper and handed them to a loved one and they became disabled, I as a physician would be bound ethically and morally according to medical ethical principles to honor those wishes. So in some ways, although one could argue living will statutes benefit us, they've legalized it a little bit too much. And in fact, the whole process, in fact, one of the negative things that is said about the Quinlan case is it brought a lot of strangers to the bedside. It brought, lawyers and ethicists and, people who were never there. Rothman has a book, Strangers at the Bedside. All the new players that were brought to a process that, for eons was a very personal process within the family. The Quinlan case, not to elaborate too much further, but Quinlan case asked that a prognosis committee attest to the fact, before the respirator could be removed, the Supreme Court said a prognosis committee would have to evaluate Karen and determine that she could not return to a cognitive sapient state. Okay, the prognosis committee got together. She could not return to a cognitive sapient state. Therefore, the respirator could be removed. Well, what the Quinlan case did was add another layer, to the intimate decision-making. You have to come in front of the prognosis committee. And out of that came the ethics committee. I mean, I'm so proud of our ethics committee at the medical center, but we are another layer of interaction between the patient and the family and the physician. I hope that we do good things for the most part, but we have brought a lot of new players, a lot of strangers to the bedside where often they don't belong and often they don't help.